It was a country about which I knew very little. But very shortly after I shifted my research focus to the topic of corruption and anti-corruption, the Lava Jato investigation began. And if you were someone who was actively interested in the field of corruption and anti-corruption, you couldn't ignore Brazil. It was one of the most important countries in the world with respect to its anti-corruption efforts. And at that time, as many of you may know, it wasn't just that what was happening in Brazil was important in Brazil, but Brazil was very much a model or a positive example that many people, many countries looked to as a demonstration of the possibility of making substantial progress in the fight against corruption. And that was significant because corruption is a very important problem in many, many countries around the world. It's a very difficult problem to address. It's very hard to fight corruption. It's so deeply, in many places, it's so deeply entrenched in the political system, and the elites, the political elites and the business elites have a kind of impunity. Right? The corruption creates this kind of vicious cycle where their corrupt activities give them the power and resources to corrupt the institutions of justice, which gives them an impunity that allows them to continue to engage in corruption. So it's very difficult to break that vicious cycle. And most of the examples that people would look to, modern examples of countries in the global south or the developing world that had broken out of that vicious cycle, tended to involve an authoritarian or quasi-authoritarian regime, a place like Hong Kong or Singapore, or a major disruptive political or economic transformation like the fall of the Soviet Union or the collapse of some of the Southeast Asian governments after the 1997 Asian financial crisis, or substantial outside pressure from countries or institutions like the IMF that really had the leverage to try to force through substantial reforms. And so Brazil really stood out as an example of a country that looked like it was making substantial progress against corruption, that was a democracy, a young democracy and a challenged democracy in some respects, but still a democracy, where, although obviously there were political changes, there wasn't anything like a huge disruptive break like you saw in 1989 in Central and Eastern Europe, and where the change seemed to be homegrown. Of course, there were outside influences, there were outside advisors, but it really seemed to be coming from within Brazilian institutions. So that was one of the reasons that many people who care internationally, who care deeply about the fight against corruption, and activists and reformers in other parts of the global south were very interested in what was happening in Brazil. And it was because of that that I first had the opportunity, for example, to meet Deltan, who, although he did his master's degree at Harvard Law School, we did not know each other when he was a student. He hadn't actually gotten interested in anti-corruption at that point, and I don't think I had either. So he was at Harvard studying evidence law with some of our evidence professors, and I was teaching administrative law, so we never overlapped. But a study center at Harvard that focuses particularly on Latin America organized a panel discussion about anti-corruption in the Americas and invited Deltan to be a panelist and invited me to chair it, even though I'm not a Latin America expert, because I was interested in this topic. And then we were able to stay in touch. And I visited Curitiba about 3 or 4 years ago at Deltan's invitation. So this is my second opportunity to visit your city. So that's how I came to this. Again, I'm not a Brazil expert. I've now visited your country many times, and I've made many Brazilian friends and colleagues and gotten to know some Brazilian law professors and law students. Brazil is a very complicated country. Brazilians seem to like to emphasize to outsiders how complicated it is, and it's not for beginners, and you can't possibly understand it. So I've heard this enough times that I always feel like I need to be very careful, even after having been engaged with Brazilians for 6 or 7 years and visited 6 or 7 times. I still feel like I don't really understand it, but I'm very, very interested in it and always want to learn more. And that's really how we get to this meeting. When I had the opportunity to visit Brazil this week, I was initially invited by a law school in Sao Paulo to come give some lectures there and have some meetings there, but I reached out to Deltan and noted that I would have maybe an extra couple of days, and that would there be any interest in my visiting Curitiba again, because I'd had such a wonderful experience when I visited before. And he graciously said, not only yes, but I can try to find some groups of people who work on corruption issues or related issues who might be interested in having a conversation. And that's how we came here. So it's a bit selfish of me. I realize I'm not coming here with a lecture or a speech to share knowledge with you. I'm really here because I want to learn from you or have a conversation as much as anything else. I'll just close these opening remarks before we open it up to the conversation by saying, I noted a moment ago that when I first began to focus on Brazil, it was a moment of great optimism in Brazil and about Brazil with respect to the fight against corruption. And within the last several years, I think I'm not saying anything that will come as a surprise to anyone around the room, there have been a lot of setbacks. And it's been a much more pessimistic time. It seems extremely likely that the next president will not be terribly sympathetic to the anti-corruption agenda, whichever of the two leading candidates it is. I know Brazil is a deeply divided society, and I'm not going to make any political commentary other than to say that whatever you think of the two leading candidates, I don't think most people who are anti-corruption experts think that either of them will be very good for the anti-corruption agenda. And the highest levels of the Brazilian federal judiciary have also seemed much more hostile to Lava Jato particularly, and an anti-corruption agenda generally than was true when I started looking into this topic. And there's been a lot of concern, at least at the federal level. I don't know as much about the state level, but at least the federal level in Brazil, not just hostility to Lava Jato specifically, but the erosion of some of the laws and institutions that are considered important to the fight against corruption. So the independence of the crucial institutions, the laws on the books, and the powers and authorities that they give to prosecutors. So my impression, again, as an outsider, is that it's a darker and more difficult time than it was before. And so, of course, one of the things that I'm interested in learning about and talking about from Brazilians who care deeply about these issues is how to move an anti-corruption agenda forward under these new circumstances, to try to preserve some of the good that came out of Lava Jato, while perhaps learning from some of the things that went wrong or some of the arguable mistakes, and maybe rebuilding an anti-corruption agenda for the future. So that's who I am. That's why I'm here. For purposes of the conversation, there are a couple of things I imagine we could do. So the first is, if any of you have any questions for me, either about my outsider's perspective or on Brazil, or maybe just more generally about the global fight against anti-corruption, because I do try to follow developments in many different countries. I can try my best. I might not be able to answer your questions, but I can try my best based on my research and my engagement with the global anti-corruption community to talk about that. Second, I would love to hear from you about your perspective about what's going on in Brazil, and perhaps maybe have the opportunity to ask you some questions or follow-up questions to get a better understanding of what's going on here. So that's sort of what I imagine we might be able to do for however much time we have. But of course, I'm open to any other way of proceeding that my hosts prefer. And so now I will shut up temporarily and turn the floor over to you, or all of you, or how should we do this?
Obrigado, professor. A primeira pergunta, então, gentilmente foi cedida a mim, né? O que eu queria primeiro fazer uma colocação para o senhor, né? Embora, claro, a Lava Jato tenha ganho o noticiário mundial, né? Enquanto uma investigação, uma mega investigação anticorrupção, existem trabalhos similares, né? Que ocorrem a nível de estado e a nível de município no Brasil, que normalmente é conduzido pelo Ministério Público dos estados, né? E é interessante observar que, embora em dimensão mais concentrada ou menor, né, os desafios que a Lava Jato enfrentou e vem enfrentando agora enquanto desdobramento são os mesmos desafios que nós enfrentamos nos estados, né? Muito assim, em relação primeiro a nos organizarmos internamente para enfrentar grandes casos de corrupção. Então, nós temos, enquanto Ministério Público dos Estados, uma dificuldade, primeiro, institucional e estrutural para enfrentar esses grandes casos. Nós somos muito mais acostumados a lidar com pequenos casos, com casos mais simples, de menor complexidade, né? E para além desses desafios estruturais e institucionais, nós enfrentamos desafios de ordem técnica, que são os mesmos que a Lava Jato enfrentou. Nós conversamos um pouco no almoço hoje sobre isso, né? Que é quando você lida com determinado tipo de criminalidade no Brasil, e principalmente uma criminalidade econômica poderosa ou politicamente poderosa, você acaba trabalhando numa zona cinzenta ou num campo de incerteza muito grande em relação a quais são as regras do jogo que vão ser jogadas, né? E os problemas depois começam a se multiplicar do ponto de vista processual, né? E as defesas e os tribunais, eles acabam anulando investigações, anulando processos, muito tempo depois desse trabalho ser iniciado, por conta de questões de regras que não eram claras no momento em que o trabalho começou a ser feito, né? E essas regras, me parece que, na prática, acabam sendo interpretadas de uma forma diferente para esse tipo de criminalidade. O senhor, né, como observa esse fenômeno em outros países, como o senhor mencionou, poderia colaborar conosco, dizer se o senhor observa essas características também, seja nos Estados Unidos ou em outros países que já estão num nível similar ao Brasil no que diz respeito a um nível ainda de corrupção sistêmica, vamos dizer assim, no que diz respeito a essas dificuldades. O senhor enxerga essas dificuldades também em outros países que têm essas características do Brasil, e num país como os Estados Unidos ou países que já estão num nível em que a corrupção ela já não ela existe, mas ela não é sistêmica como é no Brasil. O senhor também enxerga esse tipo de dificuldade? Como é que o senhor vê essas questões que são, em menor medida, repito, realidades dos estados, dos municípios brasileiros, também do ponto de vista estrutural e técnico, similares aos que a Lava Jato enfrentou?
Sorry, I'll have to keep switching off earpiece and microphone. So apologies. So I feel like your comment and your question touches on a number of issues, which are complicated, obviously, and I think there are a few different aspects to the point that you raised that are maybe not quite the same. So let me, from what I heard, and feel free to jump in and correct me if this is not right. I heard in your comment the identification of at least 3 challenges to an anti-corruption investigation at the federal level, state level, or what have you, that concern, call them technical issues. So one is the technical complexity of grand corruption or other complex financial crime in terms of gathering the evidence and proving the case. And that a challenge that prosecutors often face, especially prosecutors in jurisdictions that are smaller or less affluent or don't have much experience dealing with these kinds of cases, is that they're just very difficult to prove. Now, again, you all many people in this room would know much better than I, because you have practical experience doing this and I don't. But I've spoken to prosecutors in the United States and elsewhere that talk about how this is hard, right? When you have a homicide, you have a body usually, and often you'll have witnesses and other kinds of forensic evidence. And when you're dealing with sophisticated white collar criminals, they leave traces too, but they're different kinds of traces. And you often need a kind of expertise or investigative techniques that large and sophisticated prosecutors' offices have, but that smaller and less well-resourced prosecutors' offices may not have. So challenge number one that I think your comment and question implicated is like, how do you address the challenge of investigating grand corruption when you need this kind of technical expertise in accounting and finance and complicated economic crime. The second problem is also technical, but technical in a different sense. The law, the procedural law or the jurisdictional law for these big and complex cases may itself be very complex, because it might not be clear which is the proper court with jurisdiction, which agencies are the right ones to do the enforcement. While you didn't mention this, we might throw in if there's a transnational dimension to the investigation, how do you handle that? And you could be in a situation where, because there's that sort of complexity, and because these cases are big and complicated and go on for many years, if you make a misstep early in the case, it can later come back to really either unravel everything or end up wasting a lot of time. And so it's a different kind of technical expertise that you would need, a kind of technical legal expertise. But even then, it's a bigger problem, because the problem might not just be technical expertise, it might be uncertainty in the law itself. So you need to make the right decision where the right decision wouldn't be clear even to the most experienced prosecutor. That strikes me as problem number 2. Problem number 3, I want to distinguish from problem number 2, even though you sort of grouped them together. And that's, what if the higher levels of the judiciary, or the lower levels of the judiciary for that matter, have themselves been corrupted or captured or are susceptible to political influence, so that you need to deal not just with uncertainty about the procedural law, but you need to deal with the problem of a hostile court, possibly, that could be actively trying to shut down your investigations. Like, how do you handle that problem? Okay, so I've already spoken for longer than you've spoken asking your question, but I try to break it apart into pieces, because I think these are all related. But I think they're different and each should be addressed. So I have some thoughts about this, but I'd actually be very interested in hearing from many of the other people around the circle here, because I suspect many of you will have more insightful things to say about practically dealing with all of these problems. But since you asked it as a question to me, I'll try to say a little about each of these things. With respect to the technical complexity, like the complexities of investigating complex financial or economic crime, yes, many countries, including the United States, that are going after grand corruption or other kinds of white-collar crime need to address this issue. Countries like the United States are typically more affluent and are therefore able to afford specialized units with specialized expertise. And you certainly see that in the US government. They're not necessarily at the state level, especially in smaller states, but certainly at the federal level. The people at the Securities and Exchange Commission and the United States Department of Justice, and for example, the fraud unit, are pretty sophisticated about these issues. And very often these are the units or the bodies that will take over these big and complex cases. The really big and complicated white-collar crime cases in the US often will have some kind of federal dimension, and therefore it's easier for the federal government to get involved. And even when they don't, they're typically going to be in jurisdictions like New York or California, which are relatively sophisticated. In less affluent countries or less affluent jurisdictions, it's harder. But this is one of the areas where a lot of international support or training programs, I think, have made a big difference. I mean, I don't know specifically what's happened in Brazil, but I certainly know there are numerous other countries where people from the US Federal Bureau of Investigations, for example, will show up to help train investigators for how to do various kinds of forensic accounting, or helping them better understand how to examine financial records, or how to use other investigative techniques that are sometimes important in these cases, like wiretaps or accessing certain kinds of records. So there's that. And it's just generally a challenging problem, but one that can be overcome. It does highlight that you need appropriate resources for your investigators, right? And often specialized units or specialized teams are really important. And in Brazil, again, I'd love to hear from you guys. It seems to me my outsider's impression is that the Lava Jato investigation, one of the things that this main task force and many of the sub task forces in different cities did was to acquire a fair amount of expertise for doing this kind of work. That I think probably went beyond what had existed in those units beforehand. There was I assume a lot of learning on the job and learning by doing and like figuring out how to do this. I hope that despite the setbacks to Lava Jato and the shutdown of the operation, that some of that expertise has been preserved and transferred to other prosecutorial bodies, so that, again, even if there's hostility to the investigation, politically or otherwise, the knowledge that was gained by those investigators can be shared and can make it easier to investigate complex white-collar crime in the future. With respect to your issue about the complex legal issues, jurisdictional matters, Brazil seems to be an extreme case in this regard, with just like not being sure what you're supposed to do. I mean, we in the United States, like Brazil, it's a federal system, so there are state courts and federal courts, state prosecutors and federal prosecutors. I can't think of that many cases where deep into the case, someone decides very far into the process that like this never should have been in federal court in the first place, it should have been in state court. Usually that ends up getting resolved pretty early on, and usually it's not that complicated in a criminal case. Civil cases is actually sometimes harder, because sometimes in a civil suit, one party will really want to get into federal court and the other party will really want to keep it in state court, and there's a lot of strategic, we call it forum shopping. If a plaintiff really wants to get in federal court, they'll try to sue in another state. So there will be two different states involved making it in federal court. Sometimes the plaintiffs really don't want to get in federal court, and they'll deliberately try to keep any federal issue out of the case, and the defendant will move to what we call remove the case to federal court. But again, usually this is more in civil cases and tends to get worked out earlier. In criminal cases, usually the question is there an alleged violation of a federal statute? And so it's less of a jurisdictional issue in that sense, and more that the state prosecutors and federal prosecutors need to work out who's going to take the case when jurisdiction overlaps. But this idea that you might only figure out 6 years later that actually the whole case was in the wrong court, I can't, maybe it's happened in the United States. I can't think of a case where that's happened. And with respect to other countries, I just don't know well enough. So I can't really answer that. But with respect to the third piece that I broke out of your question, what happens if the courts are hostile to the anti-corruption agenda? And now I can be very blunt about it. Like that's really where, and the bit about jurisdiction is just a pretext. The issue is not really that the jurisdictional law is so complicated. It's that the hostile courts are making up new jurisdictional laws as they go along to kill the cases. If that's the real problem, if the problem is, I'll call it political, not technical, then it's not going to have a technical solution. You're not going to be able to like fix the procedural rules and make the problem go away, because if the courts can't use that excuse, they'll make up another excuse. So this is a huge problem. You definitely see it in other countries, less so in the United States today, and actually in United States history, which is something I'm going to talk about at a university lecture this evening. One of the things the United States had going for it, even when the United States had a lot of corruption that looked a lot like what you see in Brazil, is that although in the United States, state courts and state prosecutors were often part of corrupt political machines, the federal court system in the United States generally had a pretty high degree of integrity. There were important individual cases of federal judges who engaged in corruption, but the kind of systematic corruption or capture that is very common in the judiciaries of many countries around the world didn't really occur the same way in the United States. And that was a big advantage, because it took a while, but when the United States federal government at least got serious about cracking down on corruption, they could rely on mostly clean federal prosecutors and federal courts to take those cases. In many other countries, this isn't true, and it's a big problem. Oftentimes, people ask those of us who pretend to be experts in anti-corruption, if you have a systematically corrupt country and there are many of all the institutions have serious corruption, you can't do everything at once. Where should you start first? Like, what's the most important institution to clean up first? And I don't know, it might vary from country to country, but my standard answer to that question is the institutions of justice, courts and prosecutors and investigators. Because if those get captured or corrupted, it's very difficult to solve corruption problems anywhere else. Because fighting corruption typically requires, as part of the strategy, holding corrupt actors legally accountable for their wrongdoing. And so if the courts, prosecutors, investigators, what I refer to collectively as the institutions of justice, are captured, corrupted, or politically biased, then it's very, very hard. So that often needs to be your number one priority for cleaning things up. After that, I'd say the electoral system and revenue are probably the second and third things that are top priorities, because if the political system is corrupted, it's very difficult to make progress. And a lot of things you need to do to fight corruption require substantial resources. And if your revenue system is corrupt, then the state won't have the resources. Now, but I still haven't answered the question about how you do it. There's no easy answer. Some countries, a few countries, have actually created whole separate court systems or court chambers to try to deal with this problem. Indonesia is probably the best known. It created a system of anti-corruption courts called the Tipikor courts. Ukraine, before Russia's invasion disrupted everything, had just recently, within the last year or two, launched this new high anti-corruption court that involved a panel of foreign experts in the selection of judges. Right? The panel of foreign experts had the authority not to choose the judges, but to veto judicial candidates whose integrity was suspect. This is something that Ukrainian civil society groups had pushed very hard for, because they believed that if the Ukrainian political process had sole control over picking judges for the anti-corruption court, that it wouldn't work. In all these cases, though, the very highest court, the Supreme Court of a constitutional court, isn't part of these specialized systems. And so if your Supreme Court is captured or politically biased or corrupted, it becomes very, very hard. I think you need to basically push for personnel changes on the court or fundamental structural reforms in the court itself. And maybe you have to hope that even a politically biased Supreme Court is not so corrupt or so craven that they really will just acquit everyone. So, and it varies, right? So some countries, the court is biased or somewhat captured, but if presented with really egregious evidence of really egregious corruption involving somebody other than the president, right, that they'll say, no, we're not going to let that go. So I think that's the best you can hope for. There's not much you can do internal to the system as a prosecutor if you're facing courts that are just overtly hostile, except maybe, I'll add one last thing, strategically picking your battles to the extent that you can. It doesn't help if the court is unwinding cases where the conviction was 5 years ago and they suddenly change their mind. But, sometimes you need to think strategically, if I bring this case, do I have a reasonable probability of prevailing? And if I don't prevail, am I actually going to set the cause back because the court will make up some new law that'll make it even harder to push other cases? So I know sometimes prosecutors in many countries have to make very hard decisions about when they can push and when they need to hold back to sort of save their ammunition, if you will, to fight more effectively in the future.
Boa tarde, professor. Meu nome é Maria Melo Losso. Sou promotora de justiça da violência doméstica em Curitiba. E a minha pergunta é sobre uma distorção que eu entendo que existe na lei de aplicação de anticorrupção para o exterior, a FCPA, né? Que é sobre os pagamentos de facilitação. Por que eles não são considerados subornos? E o caso Ralph Lauren na Argentina, em 2013. Se isso não é uma hipocrisia dos Estados Unidos com relação a aplicação da lei anticorrupção no exterior.
Thank you very much. I think I can respond to part of your question, but I may need to ask for clarification for another part of your question just to make sure I understand the point that you're making. So your question concerns the United States Foreign Corrupt Practices Act. FCPA is the English abbreviation. And I suspect probably everyone here knows what this is, but just in case, this is a federal statute enacted by the United States in 1977, which prohibits US persons, citizens or corporations, or foreign corporations that issue securities in US markets from paying bribes to foreign, that is non-US public officials to obtain or retain business. The FCPA was enacted in 1977, but it was not enforced terribly aggressively for roughly 20 some years. It was enforced a bit, but there would be maybe 1 or 2 FCPA cases every year, and so not very many, and they tended to be relatively small. It was not a major central federal statute. That started to change in the late 1990s and early 2000s, and then it started to be enforced very aggressively against very large and high-profile corporations, most of which were US companies or US persons, but there were a number of non-US companies, including the Odebrecht company most recently, that where the settlement amounts were among the largest ever. The FCPA, although it contains a general prohibition on bribing non-US public officials, it includes some exceptions and affirmative defenses. And one of them, the one to which you referred in your question, is an exception for so-called facilitation payments, also sometimes called grease payments. So this exists because at the time the statute was enacted, some members of the business community and their allies asserted that in many countries around the world, it was simply impossible to get certain things done without making certain payments. The classic example to this would be something like you have perishable goods waiting in the customs, like fruit or vegetables, and they're rotting. And the customs service says, I'm not going to let these in, even though everything's been approved, but I don't care. I'm just going to hold them unless you're willing to pay me a bribe. So the sense was, if you can show that the bribe was merely to secure something to which you were legally entitled anyway, a purely ministerial duty with no discretion on the part of a public official, then you wouldn't criminally violate the FCPA's provision on bribery. I think that the facilitation payments exception in practice is virtually meaningless. That might sound like a strong statement, so let me see if I can explain what I mean by this. It's virtually meaningless for a few reasons. One is that the way the Department of Justice, the US Department of Justice, understands the facilitation payment exception is very, very narrow. They really think it's only a facilitation payments if you had an absolute legal right to some particular service from a bureaucrat that they withheld unless you gave them a payment. If there's any discretion involved, then you're not entitled to facilitation payments exception. So if you're paying a bribe to win a contract, even if you're the low bidder, right? And you said, we should have won the contract anyway. And he said, I'm not going to give it to you unless you pay a bribe, and you pay a bribe. The US Department of Justice will not treat that as a facilitation payment. I can't think of any real case, actually, where the facilitation payments exception has been successfully used as to avoid liability. Second, the US Department of Justice and the Securities and Exchange Commission, but I'll focus on the Department of Justice because the criminal aspect, doesn't bring an FCPA case every time there might be a technical violation of the statute. They only bring these cases when they think there's a big and important, either one really big bribe or an ongoing pattern of bribery. And the only cases in which people have even suggested that maybe the facilitation payments exception should have applied are cases not involving, a company sales representative making a small payment, a one-time thing. It's a systematic, over many years policy of making handouts to government officials. So again, you don't really see like one-off facilitation payments ever being prosecuted. And finally, this would only apply, what I'm about to say now would not apply to all FCPA cases. It would only apply to those where the SEC has enforcement jurisdiction, that is firms that issue securities in the United States, but those are the most important FCPA cases. The FCPA, in addition to its anti-bribery provision, has a separate provision on books and records, the accounting provisions of the FCPA, which requires you to keep sufficiently accurate books and records. And most companies that make facilitation payments don't accurately record them as facilitation payments. They try to disguise them as something else. And if you do that, even if the fact that it's a facilitation payment may exempt you from liability under the FCPA's anti-bribery provisions, you could still be prosecuted for willful violation of the FCPA's accounting provisions. So for all of these reasons, the FCPA's exception for facilitation payments, I think if I could wave a magic wand and get rid of it, I would. I think it's not consistent with best practices represented, for example, by the OECD Convention's Working Group on Bribery. But in practice, I think it is mostly harmless. Now, another part of your question, you raised this very intriguing and provocative point about whether the US policy with respect to enforcing the Foreign Corrupt Practices Act was hypocritical. And before I answer this, I would appreciate it if you could elaborate a little bit on why someone might think it was hypocritical, just to make sure I'm addressing the concern that you're raising appropriately.
Porque prevê que pequenos subornos não são considerados crimes. Diferentemente da Inglaterra, onde são considerados, onde são proibidos os pequenos subornos. E no caso Ralph Lauren na Argentina, eles faziam as mesmas práticas dos pequenos subornos previstos na FCPA. E mesmo assim, foram condenados lá com por milhões de dólares e tal. Fizeram um acordo, né? Então, é essa a diferença que eu queria saber. Para mim, é uma hipocrisia na lei. Se nós estamos proibindo qualquer tipo de suborno, não deveria ter uma exceção para pequenos subornos. É inadmissível, no meu entendimento, que uma lei preveja isso. Mas isso é o meu entendimento. Ok? Obrigada.
So again, I think maybe I'm still not quite understanding, or maybe I'm not speaking clearly. So let me try to clarify. The FCPA does not say that small bribes are okay. Facilitation payments and small bribes are not the same thing. The concept of facilitation payment does not depend on the size of the bribe. It depends on whether there's any kind of official discretion on the part of the person receiving the bribe. And again, as I said, the Department of Justice and Securities and Exchange Commission have interpreted the category of facilitation payments so narrowly that it essentially doesn't exist. So I don't think it's the policy of the United States government to say that small bribes are not unlawful. Now, it is often the policy of the United States government, often unstated, not to prosecute every violation of the FCPA. But that's, again, the Brazilian system may be different, but in the US, especially at the federal level, but at the state level as well, there's an understood concept of prosecutorial discretion, that prosecutors are not obligated to bring a prosecution every time there's a violation of the law. Prosecutors need to make a discretionary judgment about whether bringing the prosecution would be in the public interest. And oftentimes, if it's a small one-time technical violation of the law, the prosecutors might think this is just it's not worth it, not worth our resources. Now, with respect to the Ralph Lauren case, I think I'm still just not understanding where the hypocrisy would be. So the hypocrisy would be if the United States government, announced one policy, but then in practice did something else. But I'm not an expert in the Ralph Lauren case. I haven't studied it super carefully, but from what I understand about it, it seems entirely consistent with stated US policy, which is the Ralph Lauren company over a period of time had paid numerous bribes to foreign public officials to secure various business advantages. And as a result, the United States government initiated an enforcement action against the Ralph Lauren company that was resolved through a settlement, which is the way virtually all FCPA cases are resolved, at least those involving corporate entities. And that settlement required the Ralph Lauren company to pay a substantial penalty for the violations of US law that it had committed. So I think I might just not be, either I'm just not understanding or I'm missing something. It's hard for me to see that as hypocritical. It actually seems to me good. There was a company that had engaged in inappropriate, unlawful activity that violated US law, and it was sufficiently serious that it was in the public interest to do something about it, and they did something about it. Why is that not a good thing?
Portuguese, can I? So everybody can understand. And my English not that good. Professor, boa tarde, prazer tê-lo aqui conosco. Eu queria fazer um rápido diagnóstico da nossa situação brasileira, até de certa forma otimista. Nós podemos dividir a história do Brasil, em termos de combate à corrupção, em antes da Constituição Brasileira de 1988 e depois da Constituição Brasileira de 1988. Que foi a Constituição, em 1988, quem deu aos promotores, né, aos prosecutors brasileiros, a autonomia para poder agir. Nós tínhamos um modelo no qual o promotor ele era subordinado hierarquicamente a uma estrutura política e havia muita interferência política que fazia com que não se pudesse agir. A partir de 88, o Ministério Público ganha essa autonomia, né, os prosecutors ganham essa autonomia, né, e a atividade investigativa passa a ser comandada pelo Ministério Público, pelos promotores, né, nesse nicho de criminalidade mais elitizada, né, de criminalidade do colarinho branco. E isso faz com que, nos últimos 30 anos para cá, nós tenhamos já avançado, eu tenho uma visão otimista nisso, nós já avançamos muito comparativamente ao período anterior à Constituição de 88. Tivemos casos de repercussão, casos famosos, como o caso da Lava Jato, mas antes até da Lava Jato, o caso do Mensalão, que foi um outro caso que chegou até um bom termo. E no âmbito estadual, nós também tivemos vários sucessos investigativos aqui em níveis municipal e estadual, não só no Paraná, mas no Brasil inteiro. O Ministério Público conseguiu se organizar como instituição, coisa lá nos Estados Unidos não é uma instituição do Ministério Público, né? Mas nós conseguimos criar aqui grupos de trabalho, a exemplo da Força-Tarefa da Lava Jato, no âmbito estadual, que tem levado adiante muitos casos de investigação e responsabilizado até gestores públicos por desvios de comportamento. No entanto, esses casos maiores, eles tiveram a repercussão internacional que tiveram pela dimensão da prática de corrupção que se identificou, e eles, me parece, aconteceram graças a uma conjugação de fatores, de momento, porque, diferente dos casos menores, que seguem sendo investigados e seguem sendo levados a bom termo, esses casos maiores dependeram de algumas condições, eu vou usar uma linguagem de mercado, inspirado aqui no Alvin Ross, que é um economista prêmio Nobel, né? Ele trabalha com a ideia de espaços de negociação no modelo ganha-ganha, né? Win-win, né? E trabalhando dentro desse modelo, nós conseguimos, com algumas pequenas mudanças legislativas aqui, uma que ocorreu em 2010, vai ser difícil de eu explicar isso, mas nós tínhamos até 2010 a possibilidade de recalcular o tempo que o Estado tem para punir quem pratica um crime, era recalculado a partir do fim do processo. Então, só para ilustrar para o professor, se pegarmos o crime de corrupção no Brasil, ele tem uma pena mínima de 2 anos e uma máxima de 12 anos de reclusão. Pela pena máxima prevista na lei, o prazo que o Estado teria para responsabilizar quem praticou corrupção é 16 anos. É um prazo razoável. Acontece que quando vem a sentença condenando o réu, pela tradição interpretativa brasileira, a pena é fixada no mínimo legal. Tende a ser fixada, pelo menos, a partir do mínimo legal. De 2 anos. 2 anos, jogado numa tabela que existe para calcular o tempo, faz com que o prazo que eu tinha para responsabilizar não era 16, mas sim 4 anos. Não sei se ficou claro. É como se eu descobrisse ao final do processo que, na verdade, eu não tinha 16 anos para chegar até lá, e sim apenas 4. E olho para trás, no passado, e digo, pena que já transcorreu esse prazo. Então, está, na linguagem jurídica brasileira, prescrito. Não sei como é que você vai traduzir isso, né? Ou seja, o Estado não pode mais exercer a sua pretensão punitiva. Então, essa lei que existia até 2010, ela sofreu uma pequena mudança e, no curso da investigação, ela não opera mais. Então, isso faz com que o Estado, a partir de 2010, o Estado brasileiro consiga avançar em casos de investigação sem ficar preocupado que, lá no fim, o recálculo do prazo vai impactar naquilo que se investigou. Então, essa foi uma mudança legislativa que muda um pouco o cenário. Isso começa a impactar ali em 2014, bem no ano que começa a Lava Jato. Porque os crimes que foram descobertos em 2014 aconteceram em 2010, 2011, 2012, 2013. Aí tivemos uma segunda mudança legislativa em 2013, que foi decorrência até de movimentos sociais de rua, inconformados com a situação caótica do país, então, que o Congresso Nacional, reagindo àquelas manifestações, acaba editando uma lei, que é uma lei anticorrupção, no âmbito administrativo, para punir administrativamente empresas, e também uma outra lei que melhor regulamentou o que nós chamamos de colaboração premiada, que seria um modelo de plea bargaining à brasileira, se é que dá para dizer isso. Essas mudanças legislativas todas vieram secundadas por uma interpretação da Suprema Corte Brasileira, em 2016, que, mudando o seu entendimento, passou a dizer que no Brasil era possível executar as penas daqueles que foram condenados a partir da confirmação desta sentença proferida por um juiz em primeiro grau por um tribunal. A partir desse momento, mesmo que estivessem pendentes recursos, appeals, para as cortes superiores brasileiras, ainda assim a pena seria executada, que foi o que levou o Lula à prisão. Todo esse cenário criou, então, o que a gente chama de condições de mercado para que a Lava Jato avançasse a passos largos. Bom, o sucesso da Lava Jato, em termos investigativos, provoca uma reação do establishment brasileiro, que começa a minar cada uma dessas reformas, criando formas de interpretação ou mudanças legislativas que esvaziassem essas chamadas condições de mercado. Eu pergunto para o professor se esse tipo de reação das estruturas de poder no âmbito da história norte-americana, no enfrentamento norte-americano das práticas de corrupção sistemática, se lá também se deu esse fenômeno, porque esse é um fenômeno que nós identificamos, por exemplo, na história italiana da década de 90. Eu cheguei a escrever um livro comparando a Operação Manipulite, Clean Hands, da Itália com a Lava Jato brasileira. Elas são muito, muito, muito parecidas. E eu gostaria de saber se lá nos Estados Unidos também houve, como aconteceu na Itália, a partir do encerramento da Operação Mãos Limpas, e como estamos vivendo aqui no Brasil hoje, esse tipo de reação, e se ocorreu, o que foi possível fazer para que retornássemos ao status quo ao modelo anterior, onde as coisas funcionavam, onde as condições de mercado eram propícias para alcançar. E aí no Brasil, em termos históricos nossos, eu diria assim, pela primeira vez na história brasileira, foi possível dar efetividade à justiça criminal nesse nicho de criminalidade do colarinho branco. Se isso também é um fenômeno que se identifica na história norte-americana ou não, e se identifica como é que os Estados Unidos reagiram, como país em frente a essa questão toda. E se me permitir um complemento de pergunta, eu gostaria que o professor, se possível, desenvolvesse um pouco a respeito do uso do plea bargaining como mecânica de solução de casos de corrupção nos Estados Unidos. Se, de fato, o índice relacionado a crimes de corrupção se resolve muito com o plea bargaining, e qual seria o índice, se é que o professor tem esses dados, qual seria o índice de casos que seriam, de fato, levados a julgamento? Obrigado, professor. Desculpe pela exposição um pouco longa, mas eu queria traçar esse panorama para deixar o professor com um pouco mais de ferramentas para responder. Obrigado.
Thank you. That was very helpful and very enlightening. As you noted at the end there was a lot in there, and I'm not sure I can do justice to the complexity of the questions or all of the rich, nuanced detail that you provided. I can start by trying to address what you said right at the very end about the use of plea bargaining. The settlement of cases, which is a category that would include not only plea bargaining, but also settlement of civil cases, which since they're non-criminal wouldn't involve a plea, as well as the resolution of cases through what we sometimes call deferred prosecution agreements or non-prosecution agreements, which are can be used to resolve a criminal case without a conviction. These things taken together, these modes of settlement, are by far the most common way that cases are resolved in the United States. I don't have the statistics off the top of my head, so I don't know exactly what the percentage is, but it's very, very high. With respect to cases involving corruption allegations against companies or other legal entities, I think it's close to 100%. I can't remember the last time that a corporation, as opposed to an individual human being, was put on trial before a judge on corruption or bribery charges. There are some. So the fraud charges against the Arthur Andersen consulting firm, that there actually was a trial and a conviction that was eventually reversed, although the company had gone out of business before the conviction was reversed. But yeah, it's by far the most common way to resolve these cases. Trials are more common when you're talking about individual defendants, but they're still relatively uncommon. So, I'm not sure exactly what to say about the question. I'm not sure I quite caught the question part of the question, other than to say, yeah, this is typically the way things are done. And there are a couple of reasons for this that are probably going to be familiar, because I know Brazil, especially in the anti-corruption area, has been using so-called leniency agreements or other kinds of settlement mechanisms much more than was the case 15 years ago. One is kind of an efficiency or certainty rationale. Litigation is like going to war. It's expensive and you don't know what the outcome is. So just like usually diplomacy is preferable to war, usually settlement of a case is preferable to going to litigation. From the perspective of the government, an aspect of this is that the government resources are pretty limited, right? Take the Foreign Corrupt Practices Act, which the previous questioner, who I guess has gotten up to get a coffee, had talked about. There are units in the Department of Justice and the SEC that handle FCPA cases. They're very good units with excellent lawyers. There are only a handful of them, right? And they're going after large numbers of companies that can hire armies of really good lawyers. And if they had to litigate every single case, they wouldn't be able to do their job very effectively. They might be able to do like one case a year, maybe, and it might drag on. So it leverages the prosecutorial resources. From the company's perspective, you want to get this resolved, especially if the relevant conduct took place years ago and the relevant employees maybe aren't there anymore, or you've already fired them, or there are separate actions against them. Ongoing litigation is dangerous for the company. Look what happened to Arthur Andersen, right? Eventually, that wasn't a corruption case, it was a fraud case, but eventually the conviction was reversed. But by then it didn't matter, because the initial conviction meant no one would use Arthur Andersen to do their audits. They legally couldn't. And that put the company out of business. So for both sides, there are significant advantages to settlement. And when especially when you're talking about companies, they really are much more rational calculators than individuals tend to be. An individual doesn't want to agree to penalties or possibly serve prison time if they genuinely believe they're innocent. They're much more likely to be emotional or to exaggerate their probability of winning. So when you have lawyers from the Department of Justice sitting down with lawyers from Ralph Lauren, many of whom were themselves former Department of Justice lawyers who then left to go work for the private sector, they'll hash out a deal. The second reason that you often see settlements, again, familiar from, I assume, the Brazilian context, is as part of an investigation to get evidence on other parties, right? Sometimes the government will say, well, hey, look, one of the things we're going to take into account when we decide how favorable terms we'll offer you in a settlement is how cooperative you are with our investigation. Some of that cooperation is cooperating in terms of disclosing what you company did, so we have a full accounting of the facts, but some of it could be assisting us by providing evidence on other parties. In the antitrust context, I think this has been done in Brazil now too, but for a long time, the United States Department of Justice had a leniency program where for cartels, they said officially, if there's a cartel, the first member of the cartel that comes to us and says, hey, we're part of a cartel, let me tell you who everyone else is, they don't get penalized. And everyone else, but as long as they provide adequate evidence on the other parties. So in terms of settlement, I think it's the same as Brazil in terms of the reasons. My impression as an outsider is that resolving cases by settlement in the United States is a more familiar practice. It doesn't seem as in tension with the legal culture. There's relatively little judicial involvement, unlike the United Kingdom, where judges still sort of monitor and preside over the settlement negotiations. I don't want to exaggerate this. The practice of settling cases, including big corporate corruption or white-collar crime cases, is controversial. And some people say it's a real problem that the companies are getting off by with, the huge, gigantic Fortune 500 companies are paying fines in settlement agreements that some people think are not commensurate with the gravity of the harm done. They don't do enough economic damage to the company. There are other kinds of objections as well, but certainly that's a big part of the U.S. legal culture. Now, again, I'm not sure if I answered the question, because I'm not sure I understood what the question was, but to the extent that you're just asking, like, what is settlement like in the United States, that's what I can say about it. You also asked a question after describing the situation in Brazil with respect to changes in the rules on statute of limitations and whether there's incarceration after the first affirmation of the conviction, the first appeal, and so forth, and how the U.S. or other countries have handled this. So I think there's a specific way to understand the question and a general way to understand the question. The specific way would be like, what are the rules in the US about things like the statute of limitations and when the defendant gets incarcerated? The more general version is how have countries like the US handled what looks like a backlash against a successful anti-corruption effort to deal with those kinds of problems. So in the specific version of the question, I confess my area of specialization is not criminal procedure. So what I say might be inaccurate. So don't hold me to any of this. It could be wrong. My impression is that with respect to the statute of limitations piece of this, in the US, the statute of limitations stops running as soon as a criminal indictment is filed. Also, the parties can agree to toll the statute of limitations, for example, if they're engaged in settlement negotiations. So sometimes this happens if we're up near the end of the statute of limitations, the US government is ready to file charges. They want to settle. The government's like, we're not going to negotiate with you for 6 months, and the statute of limitations is run, and then we're done. But they can go to a judge, basically, and agree to suspend the statute of limitations to allow them to continue to do this, hopefully so the company can resolve the case without the indictment. There are rules about a speedy trial. You have a constitutional right to a speedy trial. So even if the statute of limitations has stopped running, if you're under the cloud of prosecution for years and the government hasn't resolved the case either by actually starting the trial or dropping the charges, then you could potentially raise a constitutional objection. That's very rare. But basically, in the US, the statute of limitations is basically to make sure the government files charges within a reasonable period of time. And then once you do that, then the case just goes. I know Brazil is complicated, and you described a lot of the complexities, which I confess I didn't follow everything, but my impression from talking to people in Brazil is that the statute of limitations rules work differently, such that defendants can, the English language expression from sports would be run out the clock. Right? Basically, it's in the defendant's interest to delay, and then eventually you can't be imprisoned at all or can be imprisoned only for a very short time. This is not the case in the United States. It's not the case in most other countries I know of. I mean, maybe Brazil's not unique in this, but when I first heard about this aspect of Brazilian criminal procedure, it was, for me as an outsider, deeply puzzling because it seems to create all the wrong incentives, right? Usually the idea is a defendant who's in legal jeopardy wants to get this resolved, right? That's why we have a constitutional guarantee for a speedy trial, so you don't have this hanging over your head forever. And so once the case has been brought, right, you don't want the government to delay 15 years and then bring charges against you 15 years after the fact. If the government's got a case to make against you, they should make it now, and we should get this resolved. And exactly as you say, if you don't have that, defendants have a very strong incentive to delay. And this is compounded also, as you say, by the fact that in Brazil, you have a right to, I can't figure out how many appeals you get, but it seems like a lot. Yeah, like that's a lot. And when it's not either one of these things is a problem. When you put them together, it seems to me, again, speaking as an outsider with appropriate respect, because there are aspects of your system that I might not understand, that might make more sense if I understood your system better. As an outsider, it seems like you put these two things together and it creates an even worse problem. And that problem becomes even worse than that when you combine it with the last feature that you mentioned, which is that you can't be incarcerated until after every one of your 30 appeals is exhausted, and maybe even then not at all, because the statute of limitations has run out. So you put these three things together, and it seems to create a situation that fosters a kind of impunity, right, on the parts of potential defendants, but not all defendants, right? Rich and powerful defendants. We were talking about this over lunch. One of the things that's very striking about this system is that these very strong protections for the defendants don't help the 18-year-old kid who's arrested in the favela for selling a small quantity of drugs. They can't drag the process out through 30 appeals and, invoke the statute of limitations and all that stuff. They go to jail under often horrible conditions, but like the wealthy people can take advantage of this. So this strikes me as a really big problem. With respect to the specific aspect, as I said, in the United States, the statute of limitations issue is different. Typically, you're going to be incarcerated after your conviction is affirmed. You don't have 30 appeals. In the federal system, you get one appeal as of right from the trial court to the Court of Appeals. Then you can petition, you can ask the Court of Appeals to rehear your case en banc, but that's discretionary and is usually rejected. Then you can petition the Supreme Court to take your case, and that's also discretionary and usually rejected. Under ordinary circumstances, you will start serving your time before the Supreme Court has decided what to do with your case or resolved it. There are exceptions. If the Supreme Court, when it receives your petition, thinks there's a really serious issue here, that possibly your conviction was not lawful, they might grant your request to stay incarceration pending the Supreme Court's resolution of your case. This happened in one of our very important recent corruption cases that implicated the former governor of the state of Virginia, Robert McDonnell, in a corruption scheme. And in that case, McDonnell was convicted. His conviction was affirmed on appeal. He filed a petition with the Supreme Court, and in connection with that petition to the Supreme Court, he petitioned the court to stay his incarceration until the court had resolved his case. And in that case, the Supreme Court granted it, which foreshadowed what the court ultimately did, which was to reverse his conviction. I think probably incorrectly. It was a unanimous decision, 9-0, and I was not a fan. But that's just to say, in the U.S., the law is a little bit complicated. You're usually incarcerated after your conviction is affirmed on that first level of appeal, but you can petition to the Supreme Court to keep you out of prison. And the Supreme Court doesn't usually grant these, but can sometimes. Your more general question was like, what do you do when your efforts to fight corruption start to pay off and then there's a backlash against them? In modern US history, I can't think of very good examples of this. We haven't had something that really resembles, I think, what's happened in Brazil over the last several years. I think if President Trump had won re-election, we might, because he was very angry at the United States Department of Justice for not just doing what he told them to do. This relates to how you started your comment about the importance of the independence of the federal prosecution service. That didn't happen. If you look further back in US history, and this will be a general topic I'm going to discuss in this evening's remarks at the university, you see something like this, but I would say you don't see the same kind of backlash to undermine institutions so much as you see the anti-corruption or good governance agenda kind of being suppressed or falling away. So sometimes you get this sort of push forward and then it stalls, or people try to undermine it in various ways. The two examples that I'll give you are first, in the 1880s, in the early 1880s, after nearly 2 decades of struggling and advocacy, the United States finally enacted its first federal level civil service reform bill, which moved the United States from a patronage system to a what we sometimes call a merit system, or a non-political form of selection. And that was a very important accomplishment. But even though the bill passed by large majorities, many politicians didn't like it very much. And the original bill only covered about 10% of the federal workforce. And there were only 2 states at that time that followed the federal government's example by enacting state-level civil service reforms. And so then throughout the rest of the 1880s and into the 1890s, federal civil service reform really stalled. So it wasn't so much there was a backlash against it. It wasn't like there was a move to increase patronage, but the movement was really held back. And we went for nearly 2 decades with that major achievement not really realizing its full potential. And then finally, when you get into the late 19th century, and especially the early 20th century, you see a revival. And then you start to see an expansion of the merit system to cover more federal civilian employees. But you don't see a backlash in the sense that you see a push back to the civil service system. It's more a refusal to actually expand the merit system. The other example I was going to mention also includes this early 20th century period. The first decade and a half of the 20th century was a period of major reform in the United States, good government reform associated with the progressive era. Some criminal prosecutions, but a lot of other kinds of reforms that were very important. And then in the 1920s, that really stalls. You get a very conservative administration, especially in President Harding, who was not very interested in the good governance agenda. And there are a lot of scandals in Harding's administration. There's not that much evidence that he personally was directly involved in large-scale corruption, but he sort of didn't do much if the people very close to him, including his interior secretary, were taking enormous bribes to give away leases to drill for oil on federal land. So that was a period of major setback. The last thing I'll say, I mean, this has been a very long answer to a very long question. I just want to circle back to something you said at the beginning, which I think is important, and that's that Brazil's made great progress since the pre-1988 period. And I think that's really important to keep in mind, especially in a difficult time, because things are better than they were. I sometimes think if you're halfway up climbing Mount Everest and you look up and you can't see the top, you can feel like I'm never going to get there. This is hopeless. But if you turn around and see how far you've come, then there are reasons to feel a little bit more confident, like we've actually done a lot. So there's a lot more to do. But yeah, I do think it's important to keep that optimism and not to be overly pessimistic about impossibility. There has been a lot of progress. I will say just one more thing, actually, I do think is important about that. And it's based a little bit on my experience in the United States and also what we've seen in the last few years in Brazil. These formal guarantees of institutional autonomy are very important, but so are informal norms or understandings of proper behavior. And one of the things that was striking about President Trump's administration is we Americans were reminded about just how much we depend on informal norms to preserve the independence and integrity of our justice institutions. We actually have fewer formal safeguards than you have in Brazil in terms of the formal independence of the Department of Justice. And when we saw a president who directly challenged those norms and tried to make the administration of justice subservient to his will and political interests, how fragile those barriers were and how important the informal norms were. I mean, one of the things that was so striking about Robert Mueller's report is that there were several instances where Trump ordered his subordinates, that is his own political appointees, to do certain things to interfere with the investigation into President Trump and his allies. And those subordinates just refused to carry out the orders. They just kind of ignored it. They didn't say no, but they just didn't do it. I mean, the fact that President Trump did not subvert our institutions more completely was basically because of insubordination, right? Which you're not supposed to do. Like if you're the support of the president, but there was this idea that it would just be improper. So the norms held, but barely. In Brazil, again, I want to be careful because I'm not an expert, but my Brazilian friends have told me things and I've read things that suggest to me that despite these very important institutional safeguards for the autonomy of the Federal Prosecution Service, if you get political leaders and who are determined to subvert the independence and autonomy of those institutions, they can do so if the informal political commitments to autonomy don't hold. So while the formal institutional guarantees in the Constitution are absolutely vital and extremely important, we need to remember not to place too much of our faith in what I believe it was James Madison called parchment barriers. Right? The words on the paper by themselves aren't going to save us. There needs to be a genuine cross-party or nonpartisan commitment to certain norms of independence and ethics and integrity. And to its credit, the career people in the US Department of Justice and some of the political appointees maintained that tradition, even in the face of extraordinary political pressure. But if they hadn't, then it wouldn't matter if we had different words on the page. The institutions wouldn't have survived. And I think that's also a very important lesson for Brazil right now. Not to take issue with anything you said, all of which I agree with. It's just to emphasize that other dimension of how we preserve the integrity and autonomy of our institutions of justice.
Meu nome é Alexandre. Eu gostaria que o professor fizesse uma aproximação, talvez de um conceito ou de elementos que o professor considere importantes em termos de corrupção, porque ainda que usualmente mesmo uma criança possa dizer não, eu sei do que se trata, vamos falar de corrupção, quando se vai deter mais tecnicamente, nós podemos falar de corrupção pública, corrupção privada, corrupção antecedente, corrupção subsequente, e mesmo na terminologia, né, ela vai variar no inglês, bribery e corruption, no espanhol, cohecho, e assim por diante, mesmo corrupção no esporte. Então, que fizesse, a partir dos seus estudos, enfim, mesmo a importância das normativas internacionais na formulação de anos nesse conceito ou nessa aproximação, o que o professor considera importante? Talvez aproximando a um conceito ou os elementos, né? Talvez algo como quebra de regras pudesse ser uma aproximação. Obrigado.
So if I understand the question correctly, it has to do with how we define the concept of corruption and whether it's important and what that definition would be. So the word corruption in English, and I suspect the translation of that word in Portuguese, has many different meanings. And none of those meanings are the single correct right meaning. Many words that we use can mean different things in different contexts, and many words that we use have uncertain, blurry boundaries. And I tend to think it's not that worthwhile to spend too much time arguing over the precise definition of corruption. I say this in part because as a university academic who studies corruption, I notice there are a lot of university academics who study corruption who seem to write like long articles, article after article, about the definition of corruption. And I tend to think it's not super useful. Partly because as a legal matter, as you say, most countries don't have a crime of corruption. They'll have a bunch of specific crimes, things like bribery, embezzlement, illicit enrichment, money laundering, and so forth. Sometimes, as in the United States, the word corrupt or corruptly will appear in those statutes. So we have to have some understanding within the meaning of the law, like what does it mean to do something corruptly? And in US law, typically that word is understood to mean with a sense of its wrongfulness, with the sense that, that you know you're doing something wrong. But as a legal matter, we don't need to precisely define it because it's not itself a crime. Like at least in the U.S., maybe Brazil is different, but in the U.S., you don't commit corruption. There's a specific statutory provision that has certain elements that are listed in the statute. The government has to prove the case. Conceptually, I do think it's useful to have a general sense of what we're talking about. And there is a kind of standard international definition of corruption. So non-governmental organizations like Transparency International and multilateral institutions like the World Bank and the IMF use variants on the same basic definition. There are some slight differences in wording, but basically it's something like the abuse of entrusted power for private gain. In an earlier period, they would say the abuse of public power for private gain, but then exactly as you say, there's issues of, well, you can have corruption in private sector organizations. For example, in the United States, recently we had a big scandal with university admissions where parents were bribing university officials to falsely claim that their children were gifted athletes who would get a special privilege in admission. And most people think that's corrupt, but except at the public universities. When this happened at private universities, there was no public power, but it still seems corrupt. So again, the Transparency International modified its definition to say it's the abuse of entrusted power for private gain. That definition has all sorts of ambiguities and gray areas, like what exactly counts as a private gain? What does it mean to misuse your power? Typically, people who think a lot about this have said the concept of abuse of power implies a deviation from some norm or standard. And so to figure out what's corrupt, we need to figure out how is that norm or standard determined. And there are three main ways to do it, all of which have some problems. One is by reference to law. So the law determines what's corrupt because the law determines, or if it's a private sector institution, the institution's own rules determine what's permissible or not. A second is by reference to public opinion, so social views. What do the people think is proper or improper? And those can be different because sometimes the law will technically permit something that most people think is wrongful, or the law will forbid something that most people think is actually totally okay. And then the third possibility is by some reference to some objective standard or philosophical standard of appropriate government or appropriate official behavior. And I won't go into all the details about all the debates about this. I'll say in practice, there are all sorts of interesting theoretical divergences between these definitions. In practice, most people who work in this area, there's broad overlapping agreement about what we're talking about. Bribery, embezzlement, nepotism, conflict of interest, there are gray areas, right? There's some things where people can legitimately argue, is that really corrupt or not? But that's true of a lot of our concepts in the sort of human world. So what's a war, right? We can try to come up with a definition of war, but there's going to be some military combat that, like, well, is it really a war? I don't know, kind of close, maybe. Some people will, for counting purposes, set a certain number of battle deaths. Like to be a war, it has to have a minimum of 5,000 combat deaths. Well, okay, like that helps for counting purposes. If there's 4,999, is it really that different than from if there's 5,000? What's a city? Like people define it different ways. So what I mean by this is not these concepts are useless. It's just that there's some gray areas and we live with it. Corruption, as I talk about it, it's really just a shorthand for a cluster of related forms of misconduct or dishonest conduct that, as the Transparency International and World Bank definitions suggest, involves some kind of a betrayal of trust. So that's what I think, to me, makes corruption as a concept different from just fraud. Now, ordinarily, in an ordinary fraudulent transaction, I tell you that, I'm going to sell you 1,000 acres of valuable agricultural land if you give me such and such amount of money, and you give me the money. And then when you get to the land, you discover it's all swamp. And by the time you try to find me again, I've fled to the Bahamas. Like, that's fraud. But there's not like a betrayal of public trust in the same way as if you're relying on me as your governor, or as your agent, or as somebody who's, again, been entrusted with certain duties of loyalty to act on behalf of some other agent or entity, like maybe the whole public. So for me, that's sort of the essence of corruption. It's this betrayal of trust. I think that's what Transparency International and the World Bank are getting at when they talk about an abuse of entrusted power. Within the concept of corruption, within that definition, there are all sorts of things that are arguably different. right? There's grand corruption, petty corruption, there's venal corruption and instrumental corruption, there's political corruption and bureaucratic corruption. Like you can divide this. And again, some people write long articles with typologies of corruption. And I think these distinctions can sometimes be quite useful in certain contexts. I'm not a big fan of typology for typology's sake. You know, you can cut things up in different ways and make different grids and different charts, but these are really just labels that we use to be able to speak more efficiently about clusters of related concepts. So I don't actually spend that much time. I mean, when I started getting to this field, I read a bunch of these articles about defining corruption. I kind of got my head around it and then decided, okay, get a basic sense. You understand where the ambiguities are. You sort of learn to live with them, and then you move on to try to figure out how to understand the problem that you're interested in.
Boa tarde, professor. Boa tarde, professor. Aproveitando, logo na introdução, o senhor fez menção a duas, que eu me lembre, duas experiências, né, no combate à corrupção, especificamente tratando ali de órgãos governamentais, de órgãos jurisdicionais, né, salvo engano, na Ucrânia, o senhor mencionou, e na Indonésia. E aproveitando que o professor Rodrigo Chemin questionou e falou sobre a experiência italiana, dessa reviravolta, digamos assim, do poder público, né, por assim dizer, em desfavor das investigações, algo que foi muito rápido, né? A reviravolta na Itália foi mais rápida do que a que está acontecendo hoje no Brasil. Embora o senhor tenha dito que nos Estados Unidos o senhor não tenha uma referência de algo semelhante a isso, essas reviravoltas, o senhor, nos estudos que o senhor fez sobre a temática em outros países, o senhor encontrou algo parecido, vendo hoje, né, que já houve um decurso mais longo de tempo na Itália, que o resultado dessas reviravoltas foram muito negativas, né, para o tratamento do tema corrupção no país. Se o senhor já viu isso em outros países, e o que o senhor imagina que nós podemos, né, assim, ter aqui para o nosso país, né, diante de tudo isso? O senhor conseguiria fazer uma projeção com base nos seus estudos?
In response to the very last part of your question, if I can predict what will happen in Brazil, the only honest answer I can give is no. I'm not very confident in my ability to forecast, especially given how complicated the situation is. It's also very difficult to figure out the long-term effects of these developments. And by long-term in this context, I mean decades later. And Italy is a good example of this. I'm not an Italy expert any more than I'm a Brazil expert, but from what I've read, there's actually an ongoing debate about whether the so-called clean hands, mani pulite investigations led to substantial long-term progress on this issue in Italy. And it's very interesting because some people take the position that the backlash against mani pulite completely reversed the gains, and ultimately, the investigation may have led to the rise of Berlusconi. Again, a lot of eerie parallels with Brazil. It's almost like you guys are just like Italy 10 to 12 years later. But others have argued that despite the backlash, the mani pulite investigations had long-term positive impacts in Italy. It did lead to certain important legislative reforms in the election law or the campaign finance laws, the details of which I don't know, but I recall that reading people who said there were actually some important legal changes, and that the Italian political culture still has a lot of corruption, but it's not the same as in the pre-Manipulite world, partly because that operation demonstrated that it was at least possible for a lot of this bad conduct to be unearthed, and it made people's lives really difficult for a long period of time, even if they eventually succeeded in mobilizing against the magistrates and others who were pushing this forward. So those would be reasons, again, the theme of optimism, those would be reasons to be, I think, optimistic that despite the backlash against Lava Jato, and that in all likelihood, your next president will be very hostile to the anti-corruption agenda, no matter whether it's the far left candidate or the far right candidate, that nonetheless, the fact that that operation occurred may have long-term positive consequences. And one possibility here that we were actually talking about in the ride over is even if politicians revert to basically doing things the way they did before, in the private sector, business people may seriously reconsider their conduct, because look, one of the things that happened in Lava Jato is that the conduct that was punished was the conduct that took place before the Lava Jato investigation got started, when people just thought, hey, this is the way we do things. I'm sure Marcelo Odebrecht never thought that it would be possible that he could be put on trial and go to jail. And even if eventually, if something happens and the conviction is overturned or nullified the way what we've seen with the high-level politicians, that I think will cause some business people to think twice if, 2 years from now, Lava Jato has been shut down for a long time and politicians are getting back to their old ways. Business leaders might think, you know what, I could get involved in all this now, but what happens 5 years from now when things change and there's a new president and we have like Lava Jato 2, like Mencelao, Lava Jato, like again, as someone was pointing out, these things go in cycles, like nothing happens. Mencelao is a kind of a big deal and then it sort of recedes. And then we get Lava Jato, which is an even bigger deal. And now we've had the backlash against that. If you were a wealthy business person who already has more money that you know what to do with, and you're tempted to get involved in these kinds of activities to become like somewhat richer, but that with respect to your day-to-day life probably really doesn't make that much difference, but there's a chance this means you might go to jail in 5 years if things change, maybe you give it a second thought. And also maybe less with the politicians, but in the private sector, some of this integrity stuff has become institutionalized, right? My understanding is that 10 years ago, Brazilian companies didn't have corporate compliance and anti-bribery programs. Maybe some of the big ones that did business internationally might have, because if they were worried about the US FCPA, maybe they would do something. But, and you all can correct me, I don't mean to be saying anything that would be insulting about Brazil or Brazilian companies. So this is just what I've heard from other Brazilians. So if I'm wrong about this, I apologize and you can correct me. But what I have heard is that it was not taken seriously in Brazil 10 years ago. And now it is, right? Now a lot of these big companies, like we have to have a compliance program. We have to have a compliance officer. And once you have those things, it's not like, oh, Bolsonaro is either president again or Lula is president again. And like, let's get rid of it. Let's fire a compliance officer because now we know everything's like, leave those things there. And that can make a difference. And young people grow up with different understandings and expectations, right? Right now in Brazil, it seems like the anti-corruption agenda is so politicized that for most people, what they think about that is going to be subordinated to whether they're bigger fans of the right wing or the left wing. But still, I think it makes a difference if people have grown up like with the understanding that, as I was saying before, with respect to the definitions, people really have this idea that politicians are servants of the people, to borrow the name of the President Zelensky's former TV show, right? If you might know this, president of Ukraine used to be a TV actor, and his most famous television program was called Servant of the People. That's what he named his political party when he ran an anti-corruption platform. And I mentioned that not just like an offhand comment. I think that's significant, right? I think in all, not just democracies, like a legitimate government, in my view, is based on the idea that the government is in some sense the servant of the people. They act in the public interest. Why else do they have this coercive power over us? That's not, in many countries, the traditional culture or ideology, right? It's still more like an old-fashioned leader and follower, sovereign and subject kind of understanding. And I hope, again, I'm trying to be optimistic, that in some indirect, subtle cultural way, events like Lava Jato will start to shift more people's perceptions of what government is for. So that's the bet. Again, I gave you a long answer. The short answer is no. I cannot predict what's going to happen in Brazil and whether it's going to look like Italy or not. The longer answer is what I just gave. I think that the ways in which things like Lava Jato or Manipulite can influence longer term developments are often subtle and indirect and multifaceted. And we can't necessarily know. especially because these things go so up and down. You know, if you ask in year 1, it looks really good. If you ask in year 5, it looks really bad. If you ask in year 10, it might look really good again, right? So they're very hard to tell in the short term.
Boa tarde a todos. Então, já que foi falado tanto em políticos, eu sou vereadora aqui em Curitiba, agradeço pelo convite do André e também pelas palavras, acho que está sendo bem rico, bem importante. Eu, apesar de tudo, também, enfim, eu também sou otimista, né? Por isso estou na política e entendo que a gente tem um longo trabalho ainda para fazer, para melhorar, é longo prazo, mas, enfim, também espero que a gente consiga. Eu ia perguntar, já que você falou da questão da corrupção no setor público e no setor privado, né? Eu, inclusive, também fui auditora contábil em grandes empresas internacionais que tinham um bom sistema anticorrupção, normas, compliance, enfim. E a gente vê agora, né, entrei para a política e agora na política eu acredito que a gente vê muito mais a corrupção, mesmo que seja pequena, né, no dia a dia, enfim, mas no setor público do que no setor privado. Apesar, como foi falado, da questão da Lava Jato, né, que no setor privado também foi muito grande, enfim, claro que a gente sabe que existe a corrupção no setor privado, mas eu ia perguntar qual é a sua visão em relação a essa questão da corrupção no setor público e no setor privado, se realmente, até em outros países, enfim, a corrupção é maior no setor público, né? E uma segunda questão, ainda também, assim, em relação à questão da corrupção, a gente também aqui no Brasil tem muito isso, que a corrupção no Brasil é muito alta, né, maior do que nos outros países e tudo, mas quando a gente vê também em relação à política, quando a gente assiste séries, por exemplo, House of Cards, outras séries, enfim, que a gente vê que na política tem coisas que acontecem em todos os países, né? A corrupção na Itália também foi citado, enfim. Mesmo assim, a gente ainda acredita que não, no Brasil a coisa é pior, né? Infelizmente. Mas também, considerando os estudos sobre corrupção em outros países, o senhor também tem essa visão, claro, né? Também existem índices e tudo, mas de que no Brasil a coisa realmente é pior, enfim, que a gente tem muita coisa para fazer. É isso, obrigada.
So I just want to make sure I understood the questions. I heard a couple of different questions. One was about corruption in the public sector versus the private sector and whether corruption is worse in the public sector or worse in the private sector. And the other question had to do with how bad is corruption in Brazil relative to other countries? Is Brazil one of the worst? Or okay, so I understood correctly? All right. So on the first, and they both have to do with measuring corruption in a sense, which is very hard to do, because for a couple of reasons. So one, back to the question about, the question about defining corruption, measuring something, counting it does require having a little bit more of a precise definition of it. And it also requires comparability. So if you're trying to measure corruption on some kind of a bar graph, how do you compare one case of a politician who embezzles $1 million to 300 cases of bribery with smaller amounts of money? Do you count the total amount of money involved? How do you compare bribes to embezzlement? Does the level of the official it's very hard to do a kind of counting the same way we could count like the number of cars produced in a country every year is more straightforward. And right, and if what you really care is the social impact of corruption, maybe one small bribe that leads to a substandard bridge being built that then collapses and kills 300 people has a greater social impact than $1 million bribe that means that one pharmaceutical company supplies ibuprofen to a hospital instead of another one where they're both supplying basically the same product. That might be a huge bribe, but the social consequence of that bribe is much smaller than like the small. So when people try to compile these indexes like Transparency International's index, which is itself just an average of other indexes, it's like a subjective impression. And I don't, that has all sorts of problems, but I do think there's something to it, because I do think there is a core concept of corruption about the prevalence of certain kinds of dishonest behavior by public officials or others with entrusted power. And in some places, it just seems more widespread than others. And those perceptions might be inaccurate and they hide all sorts of internal diversity, but I don't think they're worthless. Some fellow academics think these indexes are worthless, and I don't think they're worthless. I think if you understand them for what they are, they at least tell you something useful. Now let me try to, with that as a preface, let me turn to your specific questions. On public versus private corruption, there are two ways to understand private corruption, so I want to make sure I differentiate them. One is, in cases of public corruption, at least bribery cases, there's often a private sector party involved. So if company A bribes government official B for a contract, that's actually what I would normally call public corruption, because it's a corruption of a public official, but there's a private party involved. And they're both culpable. And there are interesting questions about who's more culpable, or should you target more the public side or the private side. The kind of, what I was calling before private corruption was like my private college university admissions case. Those cases do exist. In ordinary markets, I think there are fewer of them and they're less damaging because of market pressures, right? So, if one widget company has an executive who's embezzling from that company, that's bad. That's bad for the company. It's bad for the shareholders. But the impact on the overall society is not as great, at least if there are 15 other widget companies, and that widget company will not perform economically as well because it's losing money because of the theft. Same thing with bribery. Now, I don't want to discount the possibility of private sector corruption existing, but I tend to think that public sector corruption is a bigger problem, both in terms of how much of it there is and how damaging it is. I think that one of the reasons people focus a lot on public corruption is because of this idea that the members of the government, especially the ones who are very powerful, have greater obligations to the whole society, right? When the executive of a company embezzles from the company, they've cheated the shareholders, but they haven't cheated the whole society. Whereas the person who takes bribes to give an important contract to a less capable supplier, or who steals money that's supposed to be for healthcare or education and uses it to buy fancy sports cars or whatever, that person has betrayed a broader public trust. So I can't measure it. Again, you can't do a simple comparison, but I actually think there's a good reason that people tend to focus on the problem of public corruption. And that includes the private sector partner in public corruption. So when I say it's a bigger, I don't mean that the public official taking the bribe is a bigger problem than the private person giving the bribe to the public official. I tend to mean the corruption of our government is a bigger social problem than the corruption of a private college. I think it's deeply unfair that some people got into the University of Southern California on athletic scholarships when they couldn't really play the sports for which they're recruited. I think it's bad. I think it offends my sense of fairness. I think a certain number of talented high school students who would have gotten into that college and didn't because of these 3 or 4 slots were given to someone undeserving. That's a genuine cost, but the overall cost to the society is not nearly as great in those private sector contexts. Now, Brazil. How does Brazil compare elsewhere? So is Brazil the worst? No. So again, one of the things I've learned, like if you study global corruption, Equatorial Guinea or Cambodia or Somalia, there are parts of the world that are far, far worse. Brazil is very important. And corruption in Brazil, I think, is a very significant problem because unlike some, not all of these other places, Brazil has so much potential. Again, I'm speaking as an outsider, so discount this appropriately. But my outsider's perception is Brazil has so much potential, economic, social, et cetera, that is not being realized because of the widespread corruption. It's a large country with great natural resources, great human resources, certain geographical advantages, and Brazil has been, over the last several decades, has been growing and has been developing. And I think that the adverse impact of corruption in a place like Brazil may be even greater than in other places. But if The question is, are Brazilian politicians like the dirtiest in the world? No, nowhere close. Like, we often throw around the term kleptocracy. I don't know if that term gets used in Brazil as well. It starts to be used very broadly to basically mean high-level corrupt officials. We say they're kleptocrats. The original meaning of kleptocracy, the literal meaning, is rule by thieves. And there are countries in the world that are kleptocracies in that literal sense, where the leaders of the country treat the public treasury as if it were their personal bank account, and will just go with their families for luxury shopping sprees in, you know, Paris or Milan or whatever, and just paying public money without even thinking about it, or using the money to build giant palaces or statues of themselves. When I went to Kyiv in Ukraine about 4 years ago, some Ukrainian friends took me to see what the Ukrainians call the Palace of Corruption, which is the residence that Viktor Yanukovych, the former president, built for himself with public money. I say it's a residence. It's a gigantic estate with a full golf course, 2 giant mansions, one giant mansion that was Yanukovych's house, and a smaller one that was the visitor's mansion that they called Putin's house, because that was where Putin would stay when he would visit. It had a museum just for his classic car collection. It had a small zoo. Like, it's crazy. If you've ever been to Paris and gone to Versailles, this is like that, except when I go to Paris, and I don't know if you go to Versailles, most of what you're thinking is, oh, isn't this cool? Isn't this beautiful? You're not really thinking about the Bourbon monarchy and the way that they just like treated the country's wealth as just for them to build these gigantic luxurious palaces. Because Yanukovych was in power so much more recently than Louis XIV, the feeling that I got from the Yanukovych, Palace of Corruption was a bit different. It wasn't, wow, look at this beautiful. It was more like, this is really troubling. And so the reason that I say this is just to kind of emphasize that there's a debate about I don't want to get into anything too complicated, but Lula and this triplex condo by the seashore, even if all allegations against Lula are completely 100% true, I've seen pictures of this triplex condo, and I've seen Yanukovych's Palace of Corruption, and we're not on the same planet. We're not in the same solar system. So no, I don't think Brazil is the worst. But I think it's bad. So you referenced the House of Cards, which was originally a British TV series. And the British series, I actually haven't seen the American series, because I love the British series so much I couldn't watch a remake. Is there political corruption in the United States or the United Kingdom? Yes, of course there is. Is there political sleaze and backroom dealing? Yes, of course there is. Is there a meaningful difference between political corruption in the United States or United Kingdom and political corruption in Brazil? Yes, there is. I think sometimes, especially my fellow countrymen who are very upset, rightly upset, about all of the problems we have in the US about money and politics and special interest groups getting unfair advantages. People like that, because of that justifiable anger, will sometimes say, our system is just as corrupt as Brazil or India or Cambodia. We've just legalized the corruption. And that's not right. I think, having spent some time studying corruption around the world, the problems in the US are very bad, but they're today at the federal level, they're not the same, in part because the most blatant, crass forms of corruption, just paying bribes, outright stealing from the public treasury, don't occur with enormous frequency. Of course, they occur sometimes, but they tend to be aberrations or exceptions as opposed to the normal way that political business gets done. And yes, money in politics is a problem. Yes, wealthy interests have unfair advantages, but they operate through other channels that I think mute their impact to some degree. The analogy that I sometimes use with my American friends to try to explain the difference is that in litigation, wealthy clients, like big businesses in the US, have an unfair advantage. They can hire the best lawyers and pay them a lot of money to work on their cases, and that's going to give them an unfair advantage. But that's not the same as a system where you can bribe the judge to get a favorable verdict. You can't just buy a verdict in US civil litigation ordinarily. You have a big advantage. If you have more money, you can spend more money and hire more lawyers. And that's an unfair advantage. And I wish the US did more to create equality in our legal system and in all other walks of life. But to say our judicial system is just as corrupt as the judicial system of, fill in the name of country, Cambodia, right? Just not true. Just not true. There's a big difference.
Quer fazer nenhuma pergunta, Pedro? Como descansar? É. Então, acho que vamos encerrar por aqui, né? Já ficamos falando 2 horas. Agradecer a presença de todos e registrar algo, assim, só queria encerrar com um registro que eu acho que peguei das últimas perguntas, né? Estamos aqui com Controladoria, com o pessoal da Câmara Municipal, promotores de justiça, e o que a gente percebe, em geral, é um momento um pouco de desânimo, né? Nesse trabalho, principalmente no momento que a gente passa no país, né? Mas, pelo que eu captei do professor, até o Rodrigo também falou isso, né? Eu acho que nós talvez tenhamos dado 10 passos para frente e 5 para trás, né? Então, há ainda muito a ser feito e nós conseguimos avançar. E talvez, né, esse trabalho, embora as mudanças sistêmicas elas não ocorram, pelo contrário, temos visto muitos retrocessos, né? Eu acho que esse trabalho granular, né, de formiguinha, que ainda é feito e a gente persiste em fazer aqui na nossa realidade, ele é muito importante para que desses 5 passos para frente que a gente deu nos últimos anos, desse movimento de vai e vem, eles possam continuar nos levando para frente, né? E hoje foi muito bacana aqui a gente poder falar sobre isso e sair um pouquinho menos desanimados, né? Todos nós com uma injeção de ânimo para continuar a fazer o nosso trabalho. Então, eu agradeço imensamente a presença, agradeço muito a oportunidade, professor, né? Sempre muito bem-vindo aqui, e agradeço ao Deltan, que fez essa ponte para nós aqui, e todos que ficaram aqui conosco até agora, principalmente a nossa querida tradutora ali, que está até precisando parar com certa urgência, tá bom? Então, muito obrigado, uma boa noite e excelente final de semana a todos.
Thank you very much. Thank you.
Vai à noite lá na Universidade de Curitiba, o resto vai falar sobre a questão dos Estados Unidos, como que eles conseguiram reverter o quadro, e depois vai jantar no Barulho. Vocês são, então, todos convidados, se quiserem, só nos avise para a gente aumentar a